Okay, welcome back. Let us now jump into section number 34, 35, 36 and 37 of Companies Act 2013. Okay, so it is very important. 34 and 35, we need to identify the difference between civil liability and criminal liability in case of misstatements in the prospectus. Okay, it is very important for the examination purpose. So maybe 4 to 5 marks may come from this area. Okay, let us try to focus on section number 34 and 35 first of all, and then we will move on to 36 and 37. Done. Okay, let us have some chart for this purpose, some flow chart. Okay, so briefly we need to understand the concept first of all, and then we will jump on to the material. Done. So imagine there is a company. Okay, there is a company which wants to issue the prospectus. Okay, that prospectus shall be issued to public, and before the prospectus is issued to the public, there are some persons who needs to authorize the same. Persons need to authorize the prospectus, okay, and that prospectus shall be issued to public. This is the sequence we need to follow, right? Okay, done. So when the persons authorize the same, they need to check whether this prospectus is correct or not. So okay, whether it is proper or not. If this prospectus, if it is made in way of misleading nature, if this prospectus is prepared, it is misleading in nature. Okay, when can we call something as misleading? Okay, when can we call this prospectus as misleading in nature? Okay, when there is something which is included in the prospectus. Okay, when these persons include some statement or omits any matter. When something has to be included, they included but it is wrong. Something has to be included which is not included. Okay, these two kind of situations may arise, which may cause for misleading nature of prospectus. And depending upon this prospectus, this public, okay, to be more precise, I'll write in place of public Mr. A. Mr. A has been subscribing the securities of a particular company depending upon the prospectus which is misleading in nature. How this prospectus has become misleading in nature? Okay, point number 1, it is been included with a statement which is wrong, or it is not having the statement, or it is not having the matter which shall be there in the prospectus. Both these cases may be the reason for this misleading nature of the prospectus. And there is one person called Mr. A who is an investor. He invested in the public, okay, depending upon this misleading nature. Okay, this is the situation we need to imagine. Okay, and later I'll explain okay, the reason or the example for this omission of a matter also later at the end of this video. Okay, for the time being, there is one person who invested in the company depending upon the prospectus which is prepared in a misleading nature. Okay, so when can we call such a prospectus as misleading nature? Okay, when there is a statement which is included in the prospectus, okay, which is wrong, or there is a matter which has to be included in the prospectus but which is not included in the prospectus at all. In these situations, we can call something as misleading in nature. Okay, then with this basic introduction, we can go on to section number 34 and section number 35. Section number 34 talks about criminal liability in case of misleading prospectus. When someone who is authorizing the prospectus, they need to check whether it is properly prepared or not. This act, section number 34 says, it is a deemed assumption that the persons who authorizes the issue of the prospectus, they know everything. Okay, after knowing the prospectus whether it is right or wrong itself, they have authorized the same. It is deemed that they know everything. Okay, so when something is included or when something is omitted in this prospectus, that is known by whom? That is known by person who is authorizing the prospectus. Okay, and it is assumed that okay, they have done this with guilty mind. This is also called mens rea. We can call that as mens rea, guilty mind. Fraudulently, the intention of this behind this is fraud. Okay, if this situation exists, then those persons who are authorizing the issue of the prospectus, these persons, okay, those persons who are authorizing the prospectus, okay, are liable under section number 447. Later, by the end of this chapter, we will be discussing the section called 447. It is the punishments which are to be imposed in case of fraud. Okay, later by the end of this chapter, we will be discussing the section called section number 447. It is a very good section, okay, which always try to impose huge penalties on the persons who commit fraud in Companies Act 2013. Okay, so now against whom these penalties will be there, against whom this section number 447 is applicable. It is the person who authorizes the issue of the prospectus which is prepared in the misleading nature. Okay, on those persons section number 447 will be imposed. Okay, now are there any defenses? Can these persons escape from the liability which may be arised because of section number 447? This is what we are going to learn. Okay, now let us jump into the material now. Okay, let us see section number 34 in detail. Every person who authorizes, every person who authorizes the issue of the prospectus, okay, that prospectus which may include any statement or which may omit any matter, okay, which may give rise to misleading nature. So those persons are liable under section number 447. Later at the end of the chapter we will be discussing section number 447. I guess you are all getting the point. Very, very clear. Can this person escape from this liability? Okay, can this person avoid the liability which may be imposed on him under section number 447? Those instances are called as defenses. Okay, so when this person can escape from the liability? Point number 1, by nature it is deemed he has committed the fraud. Now it is his responsibility to prove, okay, to prove that there is no guilty mind at all. Okay, so point number 1, first defense, he has to prove that those inclusions or omissions, inclusion of any statement or omission of any matter was immaterial. What is immaterial? It is insignificant. Though the inclusion of any statement which may be wrong or omission of any matter which may be misleading in nature, okay, but it is not so significant, it is not immaterial. He has to prove that. The onus to prove this will be on whom? It will be on, okay, those persons on whom this 447 is applicable or imposed. Okay, now coming to second defense, this is point number 1. Coming to second defense, okay, it is the person who authorizes the prospectus, issue of prospectus, okay, he has the reasonable ground to believe whatever the statement he included, okay, it is true. He had that reasonable ground to believe that the statement which is included in the prospectus is true, and he continued to believe, okay, the same up to the time of issue of the prospectus. So up to the time of issue of prospectus, he had a reasonable ground to believe whatever he included, it is correct, it is true, and he continued to believe the same until the prospectus is issued to public. Okay, these are the defenses which are available in case of criminal liability. That is point number 1 and point number 2. Okay, so the prima facie, okay, condition which must be there to impose the criminal liability is mens rea. What is mens rea? It is what? Mens rea is nothing but guilty minded. The intention of a particular person who is authorizing the same must be fraudulent. Fraudulent intention must be there. Okay, once the fraudulent intention is there, then criminal liability will be imposed. So first condition is fraudulent, okay, mind, fraudulent intention, Point number 2, once this is imposed, once this is authorized, we can call it as this person is going against the law, okay. When he is going against the law, okay, then obviously criminal procedures will be applicable, okay, criminal procedures will be applicable, okay, criminal procedures will be applicable. Point number 3, he will be considered as, okay, going against whom? Going against the state, or also called as government. In simple terms, it can be called as government, or it can be called as law. He is going against the law. Hence, the criminal liability will be imposed. Criminal liability 447 will be imposed, and okay, the penalty to be paid to whom? Government. He needs to pay the penalty to whom? Government. Okay, this is actually called as section number 34, criminal liability. 447, whatever the penalty he pays, he pays to government. He pays to the state, okay, because he is going against the law, he is going against the state or government. This is what actually called as section number 34. Here, one thing you need to identify is, nowhere in this section, okay, it is said that the person who purchased, the person who invested in the company, either it can be public, or to be precise, it may be A, okay, the person who purchased has incurred damages or not. Nowhere in section number 34 it is clearly mentioned that the person who invested in the company has suffered the loss or damage because of that misleading prospectus, okay. So it is irrelevant that whether public has suffered the damages or not, okay. It is the guilty mind which is there to the person who is authorizing the same. It is what the primary requirement is. Once it is satisfied, essential condition, once it is satisfied, section number 34 will be triggered. It is not relevant whether A is incurred any damages or not, whether the public has suffered any loss or damage. Okay, I guess you are all getting the point very, very clear, and it is section number 34 now. Let us now jump into section number 35. Okay, a quick revision for section number 35. Okay, what section number 35 says? The similar, okay, example I just want to continue. So person who authorizes what? Prospectus, okay, prospectus, and that prospectus is issued to public. To be precise, I am writing here directly Mr. A. Mr. A who has subscribed the securities of the company depending upon the prospectus which is misleading in nature, and you know what can be called as misleading nature, okay, inclusion of any statement or omission of any matter. In those instances we can call the prospectus as misleading nature, and this person Mr. A, okay, has subscribed to the securities of a company, and he suffered losses, okay, or damages, okay. Now those persons who authorize the issue of this prospectus which is misleading in nature, then these persons are now liable to compensate. These persons are now liable, okay, liable to compensate to those persons who suffered the losses. Here, what is not the essential condition? Whether the guilty mind is there or not to the person who authorizes the same is not an essential condition. Okay, the main condition here is the person who is authorizing the misleaded prospectus. Okay, depending upon those prospectus, okay, Mr. A has suffered the damages. So the essential condition here to raise the civil liability. What is called as civil liability? It is not criminal activity. What is called as civil liability? These persons who are authorizing the prospectus, okay, they are now required to compensate the persons who has suffered the losses. Okay, can I conclude few points out of this? Okay, civil liability. Who will pay to whom? Okay, all the persons who are authorizing the prospectus are paying to whom? They are paying to the person who is suffering the losses. The person who is suffering the losses. Here, the person who is authorizing the same, authorizing the prospectus is paying to whom? The person who suffered the losses. Okay, this is the first and foremost condition. So first condition must be, there must be a damage which is suffered by, okay, a particular person. Okay, then here civil okay, procedures will be applicable. Civil procedures will be applicable. Code of civil procedures will be applicable. But previously in section number 34, criminal procedures are applicable. Now in this case, civil procedures are applicable. Okay. Now the primary condition in case of section number 34 is mens rea, guilty mind. Primary condition for section number 35 is there must be a person who has suffered the loss or damage because of the misleaded prospectus. Okay, I guess you're all getting the point very clear, and this is section number 35. Let us now jump into the material now. Okay, and look into okay, the defenses which are applicable in case of this section number 35. Okay, I guess you're all getting the point clear. Section number 35. This section applies only when prospectus includes or omits any statement or matter, and this may lead to what? This will make the prospectus misleading in nature. And this section, okay, it doesn't stop here, okay, but later another condition is there and is there here, and any person who subscribes the securities of the company based on such misleaded information, okay, then such losses shall be compensated by this person, okay, who subscribed the securities. Okay, this person who subscribed the securities. Now, who will come under this person? Okay, this person includes, okay, seven persons in fact. Okay, it will be a company. Okay, it is the company. The second point, the directors at the time of issue of the prospectus, and it is the person who is named as a director with his authorization in the prospectus. Point number 4, a person agreed to become, this is proposed director in fact, he agreed to become the director after the issue of the prospectus, either immediately or after the issue of the prospectus. Okay, so point number 5, promoters. Point number 6, it is person who authorizes, okay, the issue of the prospectus. He may not be the director, okay, but he authorizes himself, he authorizes the company to keep his name in the prospectus, okay, and he authorized the issue of the prospectus also. And then last point, it is the expert, and we all know in the previous sections we discussed the expert case. In section number 26, contents of the prospectus, then we discussed the, okay, case of the expert. Okay, now these are the persons who will be liable under section number 35 if they authorized the misleaded prospectus, and any person who suffers the damages. Okay, now these 7 persons are now liable to compensate the same. Okay, done. Now what are the defenses which are applicable, which are available for these persons to escape from the civil liability? Okay, done. Point number 1, the onus to prove always will be on the person who authorizes the same. Okay, the person who authorizes the issue of the prospectus. Point number 1, he needs to prove that he withdraws his consent to become director before the prospectus is issued, and onus to prove is on such person. See here point number 3, point number 4 in fact, okay, he is the proposed director. He is not the director at all, he is a proposed director. Okay, his name is included in the prospectus as a proposed director, but he needs to prove that he has withdrawn his consent to become the director before the issue of the prospectus itself. When he proves that, okay, okay, he withdraws his consent to become director before the prospectus is issued, and the onus to prove is on such person only. Point number 2, if he proves that prospectus was issued without his knowledge or consent, and even after getting the knowledge, okay, after becoming aware of such misstatement, he has to give the reasonable public notice that it was issued without his consent. If he proves that prospectus is issued without his consent or knowledge, then he can escape from the liability. Okay, because ultimately this person who is authorizing the same, okay, this person who is authorizing the prospectus, okay, he has to give his consent, right? If he withdraws his consent before the issue of the prospectus, okay, then obviously he will not be under any responsibility or under any obligation under section number 35, civil liability. Okay, I guess second point is clear for you. That is what if he proves the prospectus was issued without his knowledge or consent. After becoming aware of such misstatement, he has given the reasonable public notice that it was issued without his consent. This is second point. Come to third point. Before going into this third point, let us discuss one point which is very, very important. Which is very, very important. Just a minute. Yes. Let us now discuss one important point. There is a director, Mr. Okay, I'll name him as Mr. Director only. There is a person called Mr. Director. Okay, he authorizes the issue of the prospectus. Okay, he included the prospectus is included with certain statements. Okay, omit certain matters. Okay, and that prospectus is being authorized by this Mr. Director. Okay, he expressed his willingness, he has given his consent, only depending upon the statement which is given by expert. Say, let us talk something which is really important. In this prospectus, some financial information is given, some financial information of the company is given, and this financial information is certified by an expert, and depending upon the expert opinion, this director has given the consent. The director has not directly given the consent, he has taken the opinion of the expert, and after considering the representation made by the expert, this director is also authorizing the same. When whatever the representation it is made by this Mr. Director, it is a true representation of what? The expert's opinion. Now, it is not the mistake of the director, it is the mistake of the expert. It is the mistake of the expert. So, in that case, this Mr. Director can escape from the liability. He has to prove that whatever the information he kept in the prospectus, it is a true representation of what? True representation of the opinion of the expert. If he proves that, then he will be avoiding the liability. Let us discuss this first point. Defenses to any person making the statement on the basis of the expert's report. Such person who acted on the basis of the expert's report is liable if it is proved that. He is not liable if it is proved that the statement made by such person, he is, in our example, Mr. Director. The statement made by such person was correct and fair representation of the statement made by the expert. Whatever it is given by the expert, it is given by the director. It is the mistake of the expert, not the mistake of the director. It has to be proved by whom? Mr. Director. Point number 2. Such person had reasonable ground to believe up to the time of issue of the prospectus that expert was competent. So, whoever the expert is there, he is competent enough to make that statement. Without the expert being the competent person, then Mr. Director will be held responsible under section number 35. The second point he needs to prove is he had the reasonable ground to believe that the expert is the competent enough to make such statement. The expert is competent enough to make such statement. This is point number 2. Point number 3. See, first of all, this expert must give the consent, right? This expert has to give the consent to keep his report in the prospectus. If he fails to give the consent, then Mr. Director will be held responsible. If he withdraws the consent, obviously its statement shall not be included in the prospectus. If it is included still by the director, then this director will be held responsible. I guess you are all getting the point. So point number 3 will be, first, expert shall give the consent. Expert shall give the consent. And point number 4, expert shall not withdraw his consent before that prospectus. See, the expert had not withdrawn his consent before filing the copy of the prospectus with the registrar. Before the prospectus is filed with the registrar, if the expert had withdrawn the consent, then Mr. Director will be held responsible. If the expert fails to withdraw, then he will be saved. Who will be saved? Mr. Director will be saved. These are the contents of section number 35. Now let us now quickly revise. What are the defenses which are available? Point number 1, it is what? Okay, this director has been withdrawing his consent, okay, of becoming director. This is point number 1. Point number 2, okay, if he proves that prospectus has been issued without his consent or knowledge, and when he becomes aware of this situation, he needs to give the reasonable public notice. Point number 3, okay, he has to prove that whatever the statement it is included in the prospectus, it is a true representation of the statement which is given by expert, okay, and he has to prove that he had reasonable grounds to believe that the expert was competent enough to make the statement, and he has to prove that expert had given his consent and he has not withdrawn his consent before the prospectus is being filed with ROC. These are the defenses against those persons to get the liability of section number 35. This is the difference between section number 34 and 35. Now let us quickly, okay, solve section number 36 also. Okay, it is very simple. Section number 36. Okay, let us try to go into the section itself. Okay, section number 36, punishment for fraudulently inducing a person to invest money. Okay, so what is called as inducing? Making other person to come into a transaction. Okay, making other person to come into a transaction. If a person fraudulently induces another person to enter into, okay, what is called as this fraudulently inducing? Okay, when a person, okay, you can write here, when a person makes any, or I'll write here, any person who is making any statement, okay, any forecasting, any statement or any forecasting, or making any promise, okay, or if he is misleading, okay, or if he is concealing the facts, okay, this person may intentionally, that is called knowingly, he is doing all these things knowingly or recklessly, any person who is knowingly or recklessly making any statement, forecasting anything, making any promises, and misleading someone, concealing the facts, okay, all this put together, okay, is called as fraudulent. All this put together is called as fraudulent. And you all know, okay, when there is fraudulent intention, section number 447 will be applicable. By the end of this chapter, we will be looking into section number 447 again. Okay, so when can we call section number 36 as fraudulent? Okay, when any person knowingly or recklessly making any statement, forecasting anything, or forecasting the prices of the securities, in fact, okay, or promises, or misleading someone, concealing the facts, all this put together, it is called as what? Concealing. And they are, okay, fraudulently this person is inducing, that is making other person, inducing another person, okay, to enter into different type of agreements. Point number 1, 2, 3. These are the 3 we need to cover now. Point number 1, any agreement for acquiring, disposing, subscribing, underwriting securities. Okay, he is inducing the other person to subscribe the securities of the company. Okay, or he is entering into any agreement for the purpose of securing the profits to the yield of securities. Yield means something what you get from the, okay, securities. Okay, just by playing with the fluctuation of the prices. Okay, fluctuation of the prices. He is inducing the other person, okay, quoting the fluctuation of the prices, and he is trying to make some profit out of it. Okay, so, okay, this is covered as a second point. Come to third point, any agreement for obtaining credit facilities. What is credit facility? Loan facilities from any bank. Okay, and he is now trying to get the facilities, loan facilities from the bank by making any statement which is false in nature, okay, which is misleading in nature. If that happens, then for all these cases, punishment would be section number 447. I guess you are all getting the point very clear. So what is fraudulent in this case? Okay, when any person making any statement or promise, or misleading or concealing any facts, Okay, concealing any facts which is false in nature, then it can be called as fraudulent purpose. And inducing another person to do these type of 3 activities, then punishment will be 447. Okay, this is section number 36, and let us go to section number 37 also. It is also very, very simple section. Now you tell me one thing, in section number 34, 35, 36, okay, the persons who get affected will be public at large, right? Depending upon the prospectus which is misleading in nature, obviously public will be okay, getting the damages. Now imagine there are many persons, okay, hundreds of people out of public, they incur such losses or damages. Now, is there any possibility, okay, for them to form an association and to, okay, file the case? Or is it the responsibility of the individual persons, Mr. A, B, C, D, to file individual cases against the company? Okay, these are the 2 conditions, these are the 2 instances you need to imagine. One, individual responsibility of particular person who suffered the damages to file the case against the company. This is the point number 1. This is point number 1. Or is it possible to form as an association, okay, the person who suffered the losses just because of the misleaded prospectus, okay, these persons can form an association. Can they file case on a company? Okay, can they file a case on company? This is the second instance. Which one is possible? Okay, section 37 is a gifted section of Companies Act 2013, okay, where persons can form as an association. These persons can form as a class, and these class of persons can take remedial action. They can file a suit, file a suit against the company. They need to appoint a petitioner, okay, they need to appoint one person who can represent them, and such petitioner will represent them in the court of law against the company. Okay, this is called class action or class action against the company. This is defined in section number 37. Is it the responsibility of individual member incurring all the costs of the, okay, costs of suing the company? Okay, no. They can form as an association, they can form as a class, and they can file a suit on the company. So, what are the advantages of section number 37? If section number 37, okay, is utilized by this class of people, then they can avoid individual suit costs or individual court expenses, filing expenses, okay, and they don't need to go to the court regularly to attend the case. Okay, on behalf of them, there will be one person who will be attending the court representing them in the company. Imagine an instance, there are 100 people who get affected by the company's misleaded prospectus. So individually they don't need to go and, okay, file a suit on the company against in the court of law. They don't need to incur the expenditure. They don't need to go to the court of law regularly. Okay, instead of that, they can appoint one person who will represent them in the court of law. This is called class action against company in case of misleaded prospectus. This is what it is called as section number 37. We have completed 35, 36, 37 and 34, 35, 36 and 37 in this session. Okay, maybe in the next session, okay, we will be covering another beautiful concepts of prospectus chapter CA Inter, okay, starting from section number 23 till section number 42. Okay, done. Thank you.